You're watching Bloomberg Law. I'm Lee Pacquiao. About a month after it was announced, we now have concrete details on the settlement between 49 state attorneys general and a smattering of banks accused of improper foreclosure practices. Here to help us walk us through the document that was filed earlier in D.C. federal court, I'm happy to say we have Matt Stoller, fellow at the Roosevelt Institute, and Bloomberg's own contributing editor, Neil Borowski. Neil, of course, was the special investigator for TARP, and Matt was a senior policy advisor to Representative Alan Grayson of Florida. Gentlemen, thank you for coming in. Welcome.
Thanks for having us.
So, Neil, I want to start with you. We were talking before about this settlement. 5 banks have agreed to pay something like $25 billion. That said, it's only about $5 billion in cash. The rest come in the form of credits. But you kept coming back to 3 numbers in particular. Why don't you walk us through them?
Yeah, and I think even the way you set that up says a lot about the settlement. Well, it's $25 billion, but it's really just $5 billion in cash, and then there's all these various credits. But I think the three numbers that leap out to me are 5, 10, and 45. 5 is 5%. So Brookings estimates that 5% of all of the potential underwater mortgages in this country are actually even eligible for this settlement. So that tells you a couple of things. First of all, it tells you in the big picture, this thing isn't doing anything as far as the very significant problem that continues to drag on our national economy of the epidemic of underwater mortgages. It also indicates, though, that the number that was announced, that was touted by the Attorney General and the Secretary of HUD, that this was going to help up to a million homeowners, is probably not going to be true. 5% is roughly about 500,000, which is half of the headline number. So right off the bat, we're looking at a settlement that is probably not going to live up to even its modest promises and isn't going to have much of an impact. So that's a place where I start.
And Matt, I wanted to ask you, there was a long period of time between the announcement and when the court documents were actually filed. Did anything, in your opinion, change in that time period? Why did it take so long to get from point A to point B here?
Well, I think the part of the reason it took so long is because the banks, the administration, law enforcement officials didn't want to give investors a lot of time to respond to the settlement in court. So it was filed with the court. But I think the details were probably set about a month ago. There were some changes in the fines. The banks are paying a slightly smaller amount, and I actually found it amusing because Allied Bank is paying a slightly less because they said they couldn't afford it.
I saw that.
Which, gives you a sense of kind of the leverage and how the negotiations were proceeding.
Right. I don't think I've ever quite seen somebody have their fine lowered simply because they couldn't afford to pay the amount that was requested. That's unusual.
Right. And of course, this is, and one of the reasons why, although this is not our topic for today, but one of the reasons they couldn't afford their fine is because the Fed decided to let them pay $600 million in dividends in the last round of the stress test. So they gave out all that cash and now don't have enough even to meet their legal obligations. Right. But I think the other thing that changed, and the thing that we didn't really know about, was that second number I mentioned to you, which is 10, and the fact that and I think this is, again, symbolic of some of the shortcomings of this whole settlement. Up to 10% of the amount of underwater mortgage credit, as you say, $1.7 billion, could be met through forgiving of deficiency judgments. Right. Now, deficiency judgments, and it's comical in a way, and it wasn't so tragic. So a deficiency judgment, that's when there's a foreclosure and an underwater mortgage is foreclosed, and the difference between what the amount of the loan is versus what the bank's able to sell it for in foreclosure. And that's a spread, and that's called a deficiency judgment, and that happens in every time, basically, there's an underwater mortgage. Now, theoretically, that gives the bank in many states the right to go after the borrower to get that money and get a judgment, and that's where the deficiency judgment. Now, in the real world, not surprisingly, banks don't pursue this. I think 95% of the times banks don't pursue this because, odds are if somebody had this big stash of money, they wouldn't be foreclosing on their house.
Sure.
So, but under this settlement, right, they're now going to get credit up to $1.7 billion of
free money.
credit on this settlement. This is stuff that, and the reason why I think it's symbolic, it's not just that $1.7 billion. There are a number of other things that they can do under this settlement, which they're going to do anyhow. They would have done anyhow. And for a settlement that was described to us when the original press conference, this was going to bring accountability. This was going to be punitive. This was going to punish the banks for what was really one of the largest frauds imaginable on our court system. And now they're going to get credit under this big headline number, which is I think, appearing to be just politically generated to try to make these guys look a little bit better for what's a bad deal, with stuff that they're going to do anyhow.
Matt, we were talking before in the green room about another one of these particular credits. The banks, for donating REO that's on their books to a nonprofit institution or a town, will get dollar-for-dollar credits. What's to say that they can't be giving over homes that were improperly foreclosed to some charitable institution and receiving credits for that? I mean, the whole point of this was to rectify improper foreclosures.
Right. I mean, it's low-value property that, if they bulldoze it, which they might have to do anyway because it might actually be costing them money for upkeep. These homes might actually have negative value. They actually get credit for demolishing them or handing them over to nonprofits or to municipalities. I mean, the whole concept that this is a $25 billion settlement is just not true because there's all sorts of games and fluff in there. But I want to actually focus on one thing that I thought was really strange. Was one of the parts of the document dump that we saw was that the HUD Inspector General actually had some pretty good investigations of what the banks were doing, and those were unsealed. And the thing that I found striking is that the HUD Inspector General said at the time of their report, Wells Fargo was and is continuing to engage in practices like robo-signing. So we're not actually talking about redressing harms that have stopped. These harms are continuing. These banks are continuing to commit document fraud, and yet we're talking about a settlement as if this is in the past. I mean, it's really crazy. This is just, I mean, I don't even know how to frame it. It's just a change to our system of property rights based on political power.
That's exactly the question. We're in a situation now where the government is basically openly acknowledging that there is a certain degree of impropriety in the way we handle foreclosures. Is this a permanent setting that the government has laid out in this settlement? Is this a template for the way forward and the new rule of law post-Obama administration?
Well, it certainly looks, there's aspects of the settlement that suggest that the government has officially raised the white flag and is surrendering to the banks and just accepting that a certain amount of fraud that will profit the banks and punish homeowners is just totally acceptable. And, that's in some of these so-called penalty provisions under the agreement. And again, we were told tough enforcement mechanisms, the toughest imaginable, $1 million fines, $5 million fines. That's what we were told a month ago. And then when they release the documents and you start looking through the fine print, you find out that there's a certain amount of percentage of bad conduct, of error rates that are totally permissible under this. 1% of they can foreclose, illegally foreclose on 1% of the total per year, and it's an
explicit admission by the government that percentage is
that won't get penalized.
Okay. No.
It's okay. So
I've never seen anything like that before.
10,000. You could have 10,000 families can illegally be taking their homes, and that's okay under this agreement if there's 1 million foreclosures.
And that's not even getting to what investors are losing. Investors in mortgage-backed securities, based on other parts of this agreement, which allow the banks to get credit for modifying loans that they don't even own. So there's a strange component where investors don't have any rights anymore either. That'll be challenged in court, but it's similar to
the Association of Mortgage Investors is up in arms about this whole issue of this is basically other people's money that we're talking about.
Right, but it's part of an overall policy continuity. You see it with MF Global as well, where the money was just vaporized, and investors have limited rights to actually get it back. Homeowners have limited rights, and it just seems like what's happening is that there's been a policy choice by the administration and by the Bush administration. I mean, it's not just the Obama administration that was doing this, to just allow property rights to be determined solely by political power and your position in the capital markets, and that's, I think, really dangerous.
Okay, we have spent a lot of time criticizing. Everyone's been criticizing this deal, as far as I can tell in the media. What should have been done? I mean, the government is in an unenviable position of trying to rectify practices that have been out in the stream of commerce for quite some time. Where should they have started, and what should they have done?
Well, it starts with anything, which is clear, articulable goals. What were the goals of the settlement? And we've heard such a hodgepodge of different goals. If the goal is to punish and bring accountability, well, then obviously this is the wrong settlement. I mean, that would have been done by hard cash penalties that were significant enough in scale with the actual conduct that occurred. So you're talking about
even if that means wiping out the American banking system. I mean, suppose for a second that they just couldn't pay.
Well, look, I mean, today or yesterday, the Federal Reserve just told J.P. Morgan Chase that they could put out $15 billion of returning capital to its shareholder. So I think we could have numbers here that wouldn't necessarily wreck the banking system. Maybe Ally, which probably should be wrecked and should be put in bankruptcy.
They're one of the five involved in this settlement.
Right. So, but this settlement isn't going to make the difference. But there's a lot of cash sloshing around these banks. They've been making a lot of money because of the taxpayer since the bailouts of the financial crisis. But if you're not going to do that, let's be upfront and honest about it and say, we're not going to have any accountability. We're not going to make this punitive. It's just going to be something to help homeowners. But then you have to fulfill that promise as well.
Well, we have that nifty new resolution authority with Dodd-Frank. Just use that. That becomes a problem, right?
All right, we'll have to see how that goes. Guys, in the final assessment, is this settlement going to stand as it was filed in court? We've seen some judges, Judge Rakoff in the Southern District of New York for one, Judge Block in EDNY, they've had problems signing off on settlements between regulators and the entities that they're supposed to be regulating in terms of the financial crisis. Is this going to get signed off on as is?
Well, should it be? I think if there's ever an example of where a settlement should not be on the basis of neither admit nor deny, it has to be this. I mean, again, going back to the scale of the bad activity here, but it is in there, and I think, frankly, I wouldn't bet that a judge is going to do something like Judge Rakoff. There's so much political pressure here for this thing to move forward. 49 state attorney generals, the Department of Justice, the major banks. My guess is that a judge is going to go along and sign off on this thing.
You agree, Matt?
Yeah, I do, but I would actually watch investors, particularly foreign investors, to see whether they start to organize around their rights as mortgage-backed security holders.
Guys, I want to thank you so much for coming in.
Thanks.
That's Neil Borowski and Matt Stoller. If you'd like to learn more about the cases and issues we just discussed today, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Lee Pacquiao. Thanks for watching.